Hello, and welcome to Harassment and Bullying Prevention for the year 2018. My name is Marcia Hokanson, and I'm with Claremont EAP. I'll be presenting the information to you in this module. The information in this module was prepared specifically for NorCal Moving and its contractors. We feel that it's very important to give everyone the same information and provide resources to our contractors. So I hope you'll enjoy the program. First of all, we want to talk about the reasons why we're doing this training and make it available to you. Number one reason is because of awareness. We want to make sure that anyone associated with NorCal Moving has this information in terms of team leaders, business owners, drivers, or anyone who's in a management or supervisory role for the organization, as well as for our internal. Secondly, we want to make sure that we have our finger on the pulse of employee morale. Employees that are happy and healthy and well adjusted tend to do a better job. They're more committed to the organization, more productive, and they provide better customer service. So that's all important in terms of our business. And speaking of our brand, we want to maintain a professionalism that speaks well for our employees as well as our customers. And that's why it's important that we all look the part, act the part, and are professional and respectful with each other as well as with customers. So all of these issues come into play in terms of quality and customer service. And if we're professional, respectful to each other, we'll have high morale. And again, we'll provide excellent customer service to our customers, and we'll get more and more business and expand our businesses. Finally, we want to make sure that everything we do with regard to our employees or our customers or each other is fair and consistent. The minute we're inconsistent, someone could say that we were unfair and perhaps discriminatory. That's one issue, but we also want to maintain that consistency in terms of how we react in various situations and in terms of applying policies. From a legal standpoint, we want to make sure that we are compliant with the various laws that are out there. And for anyone that has 50 or more employees in California, we are required to do a 2-hour training every 2 years. As of 2017, we're also required to talk about the concept of bullying in the workplace. Although the California laws may not apply to your size organization, we still want to follow the U.S. Supreme Court decisions. And there were 2 landmark cases in 1998 that strongly encourage employers to do harassment training. So that's another reason why we're doing this harassment prevention workshop for all employees and contractors. Finally, we want to make sure that we are following the federal EEOC rules. EEOC stands for the Equal Employment Opportunity Commission, which is the federal agency that governs anti-discrimination laws. So they strongly encourage employers to present harassment training, to certainly have a policy about harassment and discrimination in the workplace, and have a strong complaint handling procedure as well. So for all those reasons, we want to make sure that we are compliant with the law. So let's take a moment to talk about some of the legal requirements regarding discrimination and harassment. The first law that's out there is Title VII of the Civil Rights Act of 1964, which prohibits discrimination and harassment based on race, sex, color, national origin, ethnicity, and ancestry. There's also an EEOC law pertaining to discrimination on the basis of gender or sex. And obviously, sexual harassment is a form of sex discrimination that's prohibited by federal law. And we've seen quite a bit of news as of late regarding sexual harassment specifically. Pregnancy and related medical conditions are also a protected category under federal law. So this would be anything from miscarriages, inability to become pregnant, pregnancy itself. We cannot discriminate or harass anyone because of those conditions. Religion is also a protected category. So we have to reasonably accommodate the exercise of religion, meaning allowing people to wear religious garbs or symbols, and having a reasonable amount of time off for religious observances of holidays. Age Discrimination in Employment Act protects anyone over the age of 40. It was 40 to the age of 70, but that upper limit was removed. So basically, we cannot discriminate on the basis of age or harass anyone because of their age. Military status is a protected category. Again, under federal laws, we have USERRA, which is the Uniformed Services Employment Rights Act. We have to allow people to take military leave if it's required, and then, of course, not discriminate or harass them, and then reinstate them to the same or similar job when they return from military leave. Finally, disability is a huge category in terms of mental or physical disabilities, so we cannot treat anyone differently because of their disability, and we need to reasonably accommodate their condition. The final protected category here is immigration status, which is not an EEOC law, but it is a provision of the Immigration Reform and Control Act. So we do have to verify that people can work in the United States on an unrestricted basis, but once hired, we cannot treat them any differently. Now let's move into California specific laws. The Fair Employment and Housing Act has similar protections to the federal EEOC laws, but we also have additional provisions in the state of California because we're very progressive, we're very pro-employee, we're also very multicultural and have always had these concepts in play. So we have a variety of other laws protecting people, for example, of marital status. So that's a state-specific protection. You can't discriminate on the basis of someone's marital status. You also cannot discriminate on the basis of whether people have children or not. So you can't ask about that in an interview, nor can you make assignments based on whether someone has dependents or not. Workers' compensation is a state-specific issue. Section 132A requires us to treat people who are receiving workers' compensation benefits fairly and not use that information against them in a retaliatory manner. Also in the state of California, we have protections for sexual orientation, gender identity, and gender expression. So those issues can come up, and you can certainly know about people's background, but you can't use that information in a discriminatory way or harassing employees because of those traits. Genetic characteristics is another state-specific issue that's protected in the state of California. And political affiliation is protected in the state of California as well. So it's probably better for people to keep their political beliefs to themselves because clearly no one agrees on political beliefs. It can also cause friction and conflict in the workplace, so it's probably better not to talk about politics. Union membership is also a protected category in the state of California, so employees have the right to join unions. And a big issue in the state of California is medical conditions. So there's special laws protecting people who are HIV positive, who have cancer, or atypical cellular blood traits like sickle cell anemia. But basically any medical condition is protected in the state of California, and employers have to take steps to protect that information. So now we're going to talk about harassment specifically. And we do want to remind you that harassment can be based on sex, race, color, religion, basically any protected category. It is subject to interpretation because we're all individuals that have different thought processes, senses of humor, and tolerance levels. But the basic rule should be we can't offend anyone. There is the reasonable person standard that the question would be whether a reasonable person would be offended given the circumstances. But again, we don't want it to get to a legal basis. We want to take steps to ensure that our employees always feel like they're being treated fairly, respectfully, and professionally. To illustrate some of these examples of harassment, let's talk about this one legal settlement having to do with Braun Electric Company. And basically, Braun Electric Company has to pay $82,500 to settle a sexual harassment lawsuit that was filed by the EEOC. According to this lawsuit, since 2010, a male manager continually subjected his female coworkers to harassment and a hostile work environment. Some of the manager's unlawful behaviors included grotesque sexual remarks and explicit sexual propositions. So while we don't know exactly what was said, certainly being grotesque and explicit is completely inappropriate and unprofessional. And so that was an example of sexual harassment. Here's an example of harassment based on national origin and age. It was a security firm, Guardsman, who failed to stop a coworker harassment of a guard. The situation was that this Inderpal Nayar worked for as a security guard for Guardsman, and he faced constant workplace harassment regarding his national origin and his age. He was 66 at the time. He was subjected to workplace harassment with repeatedly ridiculing his clothing and his accent, making fun of him, and making commentary about his age. The same coworker made comments about his age, and the supervisors ignored his complaints, taking no action to address the hostile working conditions. So Nayar was then involuntarily transferred, leading to a reduction of his hours and a loss of employee benefits. Therefore, he was retaliated against. So it was bad enough that he had national origin and age harassment. He was subjected to retaliation as well. Here's another situation involving sexual harassment, but it wasn't male to female or female to female. It could be any of those combinations. This was a situation where a female coworker harassed a male at Regal Entertainment Group, and they had to pay $175,000 to settle a sexual harassment or sexual discrimination lawsuit. Basically, what happened is the male employee was subject to a sexually hostile work environment by the female coworker. Both the male victim and his direct supervisor complained to the general manager, who failed to stop the harassment. The manager then retaliated against the harassed employee and two other supervisory employees who were both male and female. So the point is, once we hear about the harassment, we have to take actions to stop it. Certainly subjecting to an employee to ongoing harassment would be inappropriate. Here's another situation in San Francisco. Sutter Transfer Service is a container transport organization, and they were sued for race harassment when the trucking company allowed a supervisor to harass truck drivers with racial slurs. The driver, Lonnie Winstead, was targeted by his dispatcher with racially charged comments. He alleged that he also heard other racial slurs directed at various ethnic groups. In addition to that, other employees witnessed workplace harassment and even complained to management. However, Sutter failed to take action against the supervisor, so race harassment continued. That is going to involve a $30,000 settlement. In another situation, UPS violated federal law when it allowed supervisors and coworkers to harass and discriminate against an employee for being Arab and Muslim. Tabal Alafor, who is Jordanian and Muslim, faced workplace harassment, both verbal and physical. Alafor was called nicknames and subjected to racial comments. Alafor was also physically harassed with rocks, bottles, and tools, plus a dead mouse was placed in his lunch bag. UPS failed to take action even though Alafor repeatedly reported the harassment to his employers. So this is an example not only of national origin, but also religious harassment, clearly inappropriate and unlawful. All of these cases show that it's not just sexual harassment that we're concerned with as an employer. There's also examples of racial harassment, ethnic harassment, national origin harassment, age-based harassment, and we want to make sure that all of our policies and practices and the way we communicate with our employees is respectful and professional at all times to avoid legal issues. Now let's talk about the concept of bullying in the workplace. California law defines abusive conduct as conduct of an employer or employee in the workplace that's done with malice, that a reasonable person would find hostile, offensive, and unrelated to an employer's legitimate business interests. It may include repeated infliction of verbal abuse, such as the use of derogatory comments, remarks, insults, epithets, verbal or physical conduct that a reasonable person would find threatening, intimidating, or humiliating, or the gratuitous sabotage or undermining of a person's work performance. It's not a one-time only offense, but it says the state law says that a single act shall not constitute abusive conduct unless especially severe or egregious. But basically what employers have to do is make sure that employees are treated fairly and respectfully and are not bullied or subjected to abusive conduct in the workplace. Now let's talk about some of the practical issues in terms of rules of engagement. The first one is joking in the workplace. And while I do think it's important that you have fun and enjoy work, sometimes when jokes are in the workplace, they are about inappropriate subjects such as race or religion or politics. And that can certainly offend someone. As can name calling. It's better just to call the person the name that they have generally on their uniform, but the name that they're given. Any shortened names or terms of endearment or pet names that you might have for people could certainly be considered offensive in some situations. The same could be true of calling people boy or girl, which would be demeaning, and or any commentary like calling anyone sweetie, honey, or dear would be inappropriate. Next point is we want to be careful about our electronic communications, whether they're on our phones or leaving voicemail messages, texting someone, or communicating with them on the computer. Those are all subject to the rules about harassment, and you don't want to send anything inappropriate or unprofessional in that situation. Physical contact with employees is generally not suggested. In some cases, you might use your best judgment in terms of hugging if you haven't seen the person for a while. Sometimes you can't help it if you get hugged by a customer because you've done such a great job. But in general, you probably shouldn't touch your employees and or your customers. And certainly dating in the workplace is not suggested either, especially if it's someone that reports to you. That's clearly not a good idea. And just generally socializing with your coworkers. Of course, you can socialize with your coworkers, and sometimes that creates bonds that improves teamwork. However, a lot of times in social situations can occur, and we certainly wouldn't want that to impact your work relationships. The last comment here is about compliments. And while it's nice to give compliments, sometimes compliments are about people's bodies or something else that might be construed as suggestive, and you probably want to keep those comments out of the workplace as well. So what I've tried to do is just sort of provide you with some practical rules of engagement so that you can stay out of trouble with the areas of harassment. And so joking, name calling, your electronic communications, your physical contact with your employees, socialize with employees, and compliments are all ways that supervisors, team leaders, business owners have gotten into trouble in the past in other organizations. And so you certainly don't want your reputation marred by any activity in that area. So please be cautious, especially in those areas. So in summary, what we want to do is avoid discrimination, harassment, retaliation, and bullying. And those are all legal concepts, but I think that if we are fair and consistent and professional at all times, we won't have any issues such as the cases that were described in this training module. We want to maintain professionalism and also uphold the professionalism of the brand of NorCal and always represent that well, whether when we're in uniform and with our coworkers. Mostly it's about maintaining a separation between your social and professional behavior. Some of these situations are fine in a social example, such as flirting, joking, name calling, and those sorts of things. Those are fine socially, but that's not appropriate professional behavior. And I hope that we have been able to define that better for you and give you some parameters to work within. I think mostly it's a matter of being respectful. Certainly your employees look to you to set the stage, and we always want to maintain a sense of professional, respectful behavior. And then finally, it's very important that you understand your responsibility to respond in case you hear of a complaint. It could be another staff member making an observation or a comment about someone else's behavior, whether it was a coworker or a customer or another supplier or vendor, and you need to make sure that you respond in case of a complaint, or you could possibly be held personally liable. So the people to respond to would be your team leader, the superintendent, the salesperson calling the HR department, or any of the business owners. All of those people would be willing to hear your comments and would be willing to take action to protect the rights of employees. So that concludes the information in this short module. Should you have any questions, I would suggest going to Roxanne and in the HR department, and she can assist you with any questions or comments that you might have. Thank you very much for listening to this program, Harassment and Bullying Prevention, for the year 2018. I hope you've enjoyed the program, and I appreciate your participation.